See you in court is one way to respond when legal issues arise. Why can that approach backfire when the issue concerns global marketing? So, let's talk about the term see you in court. It is the threat to take the whole thing to a higher authority or some public forum. Suggests that some third party will be brought in to mediate or arbitrate. It is one of the ways to respond to the legal issue. But when the things start to relate with global marketing, it depends on the situation that you have to consider which solutions are suitable for you. So, there are many ways to solve the legal issues when it occurs. Two of those are litigation and arbitration. First, let's talk about litigation. Litigation involves using the relevant state and federal courts to resolve all matters. Consider disputes under an agreement. Unless the parties expressly agree to resolve their disputes by another means, litigation will be the default dispute resolution mechanism. Arbitration, on the other hand, involves two parties in a dispute who agree to work with a disinterested third party in an attempt to resolve the dispute. In arbitration, there may be one or more arbitrators who hear both sides of the issue and who make a decision. In terms of global marketing, there are a number of advantages that arbitration can have over litigation. First, speed of process. The arbitration process is fairly quick. Once an arbitrator is selected, the case can be heard immediately. In a civil litigation, on the other hand, a case must wait until the court has time to hear it. This can mean many months, even years, before the case is heard. Moreover, the cost. Arbitration is sometimes cheaper than litigation, particularly where the parties achieve procedural efficiency by agreement. The costs for the arbitration process are limited to the fee of the arbitrator, depending on the size of the claim, expertise of the arbitrator, and the expenses. But costs for litigation include attorney fees and court costs, which can be very high. Lastly, procedural flexibility. Arbitration can allow the parties to tailor procedure to the needs of the particular dispute, and is generally thought to allow the parties more freedom to agree on suitable procedure. Generally, in arbitration, procedural deadlines can be more flexible and informal. This can be an advantage for the parties in terms of reducing arguments, application over time extension, and deadlines. For example, a non-US company enters into an agreement in the US, but they are not familiar with the US court system, so they instead uses the arbitration. They might feel more comfortable being able to either directly choose an arbitrator or set parameters on who may arbitrate.